taking place in our country over the past week or so. And as I would normally say, Guyana is a very dynamic society, and in any given week, we have a number of important issues to discuss. As usual, I want to welcome our listeners on Freedom Radio who are joining us from Rob Street, Georgetown, from Freedom House, and I want to also welcome our viewers on Facebook who are joining us right across the country, the Caribbean, North America, Europe, and further afield. Once again, good evening and welcome to another program of Issues in the News. Well, the important thing ongoing in our country is the engagement taking place between a delegation appointed by the leader of the opposition and a delegation appointed by the president for the purpose of hammering out a list of 6 names that eventually would be submitted by the leader of the opposition to the president for the appointment of a chairman of GCOM. And yours truly is one of the delegates on the side of the leader of the opposition. And as you would recall, the 2 teams met on July the 1st. The 2 teams I'm referring to is the leader of the opposition and his team, and the president and his team met on July the 1st, and it was agreed at that meeting that a smaller team would be appointed that would do the hammering out of the names and would report back to the respective principals. It was also agreed that the 80 names that were originally submitted by the leader of the opposition and rejected by the president would be resubmitted for the consideration of the president. And that is so because the Caribbean Court of Justice ruled that the process employed by the president in considering the 18 names and rejecting them was flawed and contrary to Article 161(2) of the Constitution. So those 80 names would be adjusted and resubmitted. And then, of course, it was agreed that the leader of the opposition would not be disposed to names being suggested to him by the president. And I will explain that as the program goes on, because there has been great debate, discussions, and some degree of misunderstanding of that issue. And as the program unfolds, I will clarify it. Now, the 2 teams that have been appointed, as you are aware, met yesterday, and that meeting continued this afternoon. And having regard to the discussions which are ongoing, it appears as though there are certain aspects of the Caribbean Court of Justice judgment that is not clear to the government side. And I will explain what I mean. Now, perhaps it is important that I go back a little to explain that the CCJ did not rewrite, it did not amend, nor did it modify Article 161(2) of the Constitution. The CCJ merely interpreted Article 161(2), and since the 2 players in Article 161(2), the president on the one hand and the leader of the opposition on the other hand, experienced some difficulty in operationalizing and executing Article 161.2 in terms of their respective duties, the CCJ, in interpreting Article 161.2, proffered certain guidance to the two major players in the article. So whatever the CCJ said, they said that to interpret the article, not to change it and to modify it. I say so because I want to emphasize the respective roles of the leader of the opposition and the president have not changed under the article. And what I want to emphasize is that the leader of the opposition is the one who must submit a list of 6 names to the president, which must find the acceptability of the president, and the president must appoint from that list. The president doesn't have to find all 6 names unacceptable, not unacceptable. He can choose one from the 6 names. And the other important issue that I want to emphasize is that once the engagement is ongoing between the leader of the opposition and the president is prohibited from resorting to the proviso. Those issues were made very clear in the judgment. So the judgment, we have to understand that the judgment commenced with those guiding principles. There are some other issues that the judgment highlighted. Prominent among them is that the judgment, for example, I'll read so that listeners can understand that the judgment at what the judgment actually says, because a lot of it now that we are meeting is being or are being misinterpreted. Now, you would recall that while the engagement between the leader and the opposition was ongoing in 2017, a case was filed by a citizen, Marcel Gaskin. That case preceded the case filed by Zulfikar Mustafa, and it sought to enlist from the Chief Justice an interpretation of Article 161.2. And in that judgment given by the Chief Justice, certain remarks were made which the CCJ adopted and approved as part of their judgment. And among the things that the CCJ approved and adopted as part of their judgment was the following statement. It was not the case, I quote, it was not the case that the list of persons for appointment as chairman must include a judge, a former judge, or a person qualified to be a judge. The various eligibility criteria stated in the Constitution carry equal weight. You would recall that the Constitution spoke of a legal category and a fit and proper category. And what Gaskin decided is that these categories, one do not hold a priority over the other, one must not carry weight over the other, any weight over the other. In other words, persons from either category are equally qualified to be appointed or considered for appointment as the chairman of GCOM. And that has a particular history. You would recall that we had to trace the history of this article so that it could have been understood by the court. And at one point in time, there was only the legal category, that is judge, former judge, and persons qualified to be appointed as judges. That was expanded to include fit and proper persons, any other fit and proper persons. And Gaskin determined, which was approved by the Caribbean Court of Justice, that no one person in any category is to be treated as superior or more qualified than the other, that persons from each of the two categories are equally qualified. The importance of that will become clear as I go on. The other issue that I want to emphasize, which came out of the judgment and which is of some importance now, is paragraph 26 of the judgment. And this is what it says. Now remember, the leader of the opposition is to come up with 6 names, but at the same time, these 6 names, or at least one of the 6 names, must find acceptability of the president. So the CCJ said, how is it that you will arrive at this consensual position? And the CCJ proffered this view. They said that the Constitution envisages that this process, meaning a collaboration between the leader of the opposition and the president, the Constitution envisages that this process will culminate in a list of 6 names being presented to the president, none of whom is unacceptable to the president. This ultimately gives the president the opportunity to select one of those 6 persons as chairman. And then they say now, how is it that these 6 names will be arrived at? And it goes on to say, we are of the view that the most sensible approach is that before a list is submitted, the leader of the opposition and the president must communicate with each other in good faith and perhaps even meet to discuss. So they are saying, how do these people arrive at a list that will find acceptability between both of them, if not them communicating and meeting? And that is what we are currently doing. It goes on to say, the aim of these discussions must be to agree on 6 names who fit the stated eligibility requirement and who are not unacceptable to the president. In this regard, the Constitution anticipates that the leader of the opposition and the president will conduct themselves in a reasonable and responsible manner, etc., etc. It goes on to say also that the employment of the double negative, that is, not unacceptable, signals that the onus is placed on the president not to find a nominee unacceptable merely because the nominee is not the choice of the president. In other words, the president is not entitled to his perfect choice. So it goes on now to explain how do you arrive at this process. And the CCJ said that in arriving at this process, an approach must be adopted which gives the president a role in the identification of the 6 names. So that is the role that the president has in identifying the 6 names. It's not a formal role where the president has to submit. It's that the president must play some role in indicating to the leader of the opposition, look, I don't find this name acceptable. I don't find this name acceptable. I don't find this name acceptable. I may consider this name if you put it in. It is in that context that the leader of the opposition says that, look, I am not averse to the president floating a name to me. But this is a far cry from the president actually submitting formally names to the leader of the opposition. Because ultimately, the president cannot be choosing his own people, put them on a list on the leader of the opposition, and then being given a power to appoint again. That is exactly what he did with Patterson. He chose Patterson and appoint Patterson. So the Constitution is saying that, look, you have to find some mechanism whereby you indicate to each other who should go on that list, so that when the list comes to the president, it's a hammered out list with people from both categories and persons whom the president would have had an opportunity to reflect upon. And that is the spirit of the engagement that we are currently engaged in with these two small parties. Today we had another of the meetings. Yesterday, let me summarize what transpired. And you would have heard me speak about it. Yesterday when we arrived at the meeting, all we were met with was a list of 8 names from the president. And the government team or the president team was not in a position to tell us anything in relation to the 11 names which the leader of the opposition had submitted. So yesterday's meeting was a waste of time. And that is why we are saying that it was not a meeting done in good faith because of 2 things. One, they didn't come with any guidance from the president in relation to the 11 names, and that is what the meeting was fixed for. And the president is saying to the nation that, look, I want this process to be completed in a matter of days. Yet he sends a delegation to meet with the leader of the opposition with no instructions on an agreed list of names that should be considered at the meeting. Instead, he imposes upon the leader of the opposition team his own list. And then when one looks at the list itself, you find persons there who are, I don't want to say provocative, but who are disqualified by any standard. You have a prime ministerial candidate of the PNC reform on the list. You have a known financier of the PNC reform on the list. You have other people who are clearly connected to the PNC on the list, openly connected. You have Mr. Patterson again on the list. Now, at the end of the July the 1st meeting, which was held at the office of the president was on television at a press conference, and a reporter, Svetlana Marshall, I believe her name is, from the Chronicle, asked the president specifically whether Mr. James Patterson's name will be floated by the president. And the president says that Mr. Patterson is electoral history. The president says that. And then we turn up at a meeting and there is the very Mr. Patterson name on that list. So how can we conclude that the president's team is acting in good faith? I highlighted that in this judgment, the CCJ said that good faith must govern the interaction between the leader of the opposition and the president. And the CCJ reiterated that sentiment over 25 to 30 times. I haven't counted, but by memory tells me that the CCJ reiterated that good faith requirement in the engagement over 25 times. Now we went to today's meeting. And at today's meeting, the government, we started the meeting with the consideration of the 11 names. And the government or the president's team continues to maintain that the category dealing with legal qualifications must be accorded priority over fit and proper person. Exactly what the CCJ said we must not do. exactly what the Chief Justice in Marcel Gaskin said we must not do. So that was the first issue of contention at the meeting, because the government side insists on drawing up two columns, one dealing with judges, former judges, and persons qualified to be judges, and the other category is other fit and proper person. And they are maintaining most strenuously that this judicial category, so to speak, must be given greater weight and priority over the other category. So we are back to that position. Secondly, the persons who fall into that category of the 11, we are told by the government side that those names will be shortlisted. I asked about 10 times, and my colleague may have asked even more. What does that mean? They say that it is shortlisted. We keep asking, shortlisted for what? Are they qualified to go forward? They eventually said they are qualified to go forward. So at least we have 4 names that fall into the judicial category out of the 11 that, according to the government side, qualified to go forward. We asked specifically, do they meet the acceptability of the president? No, they don't, but they are qualified to go forward. So, qualified to go forward and meeting the acceptability of the president are two different things. So they are saying that they are qualified to go forward. And they're not prepared to explain what that means. They are shortlisted to go forward, qualified to go forward. And on the fit and proper category, they have disqualified, I believe, 5 names. And they offer some reasons, which we are not permitted to disclose at this stage. And 2 of those persons on that fit and proper category, or from that fit and proper category, are persons that they put one side to say that they are actively considering them. They have not reached the stage of accepting them or shortlisting them, but they are considering them. So we have 4 on this side and 2 on this side that are under active consideration. The meeting stopped at that stage, and we are to resume on Thursday. And at Thursday's meeting, we are to, if we have more names from the leader of the opposition, we are to take them forward. And secondly, that we are to report on the leader of the opposition's position on the 8 names submitted by the president. We requested that the president also adjust those 8 names having regard to the discussions which we had at today's meeting. So, in other words, some of the same reasons that apply to persons who are disqualified under the fit and proper category, we are asking that they be applied to the 8 names, and the president's 8 names or list of 8 names should be adjusted accordingly. That's where the meeting ended. I don't know if that is progress, because the language that is being spoken is so coded, you can't hold on to anything definitive coming out of the engagement. I suppose Mr. Harman, when he spoke with the press after the engagement, would have said words to the effect, I hope that I have accurately captured what transpired, and I don't want to be accused of speaking out of turn or in any way prejudicing the engagement, which is an ongoing one. The other important thing is that the government side also believe that they can resort to the proviso at any time. Although the CCJ said that once the engagement is ongoing, then resort cannot be had to the proviso. So there's another unclear issue that arose. Well, clear on our side, but the government seemed to not be able to understand that the CCJ said so. So I thought I'll give you that update on where we are in relation to those engagements. And I hope that I would have shed some light on the engagement and bring you up to speed on where we are. Of course, when we go to the telephone, I will hear your views on the matter. The other major issue that is occupying the news is the grant by the President of some respite to the Minister of Finance, Mr. Winston Jordan, which has the effect, according to those who are propounding the argument, has the effect of putting the judicial orders made against Jordan on hold. That seemed to be the impact, or at least that is what is interpreted to be the effect of this order granted by the President. Now, I have to do some more research before I make some more detailed pronouncement or opinion on that issue. But what I want to say at this stage, firstly, that what the President has done there is unprecedented. Unprecedented in this part of the world. I have never heard anywhere in the Caribbean, or in fact the British Commonwealth, that a head of state, more so the head of the executive, intervening in an ongoing judicial process in order to insulate anyone, moreover here an executive officer, insulate that executive officer from the judicial process. I have never heard that. Never heard that happen. I read the Constitution and I see that the Constitution has a provision which on its face seem to give the President the power that the President sought to exercise. But I am saying that I have never seen it done. And I want to research it a little more to see how, if such a power exists, how it should be exercised. What I do know is that Article 188 of the Constitution is the article that deals with the President's prerogative of mercy. And what I do know is that the prerogative of mercy is a power that the President has, inherited from the King or the Queen. It's a prerogative power which the President can use, but normally it is used at the end of the judicial process in deference to the doctrine of separation of powers, which allows each of the arms of government to function with autonomy and independence. in the discharge of their respective functions. That is why, for example, when a bill is going to be passed in the National Assembly, a court will not, unless in highly exceptional circumstances, intervene and stop Parliament from passing that bill if a person goes to the court and said, look, court, Parliament is passing a bill that is unconstitutional. As you know, or as you may not know, the judiciary under the Constitution has a power to strike down any law that is inconsistent with the Constitution. And I am saying to you that the court will not exercise that power until that bill passes through Parliament and becomes law. In other words, Parliament is allowed to complete its treatment of the matter, and then you go to the judiciary for rectification or a remedy. The judiciary will tell you that they cannot stop the process of Parliament from passing that bill out of deference for the separation of powers doctrine. Similarly, though the executive president may have a power, and I'm assuming that he has the power, to exercise a prerogative of mercy in relation to a matter that may concern or may be the subject of judicial process, he will only do so and should only do so after the judicial process is completed, not when it is ongoing. Here you have Mr. Jordan before the court. The Attorney General says that he's going to appeal from the full court to the Court of Appeal, and then the Attorney General, if he loses there, can go to the Caribbean Court of Justice, and only when that process is exhausted, then, in my respectful view, the exercise of the prerogative of mercy can be initiated. It cannot be initiated so that the executive can step into the judiciary and stop the judiciary from discharging its functions. It cannot happen. And that is where this is wrong. I'm going to research it, as I said, but pure instincts and pure elementary principles being applied would guide one to that conclusion. Because the president would be trampling upon, would be trespassing upon, and would be usurping the functions of the judiciary. How can that be right? Litigants now who are in the court system and now realize that they cannot win in the court system, can they leave the court halfway, leave a case halfway in the system and run to the president for a pardon? Is that what the example now being set? Is that the precedent that is being set? This must be an abuse of power and an abuse of the Constitution and a violation of the doctrine of separation of powers. Absolute abuse. And that is why I have encouraged Mr. Jonas, the lawyer who is appearing for DIPCON, to go ahead and challenge this. You cannot leave this unchallenged. This is a most dangerous precedent, because any executive officer who is caught midway in the judicial process can run to his president and run to his boss and say, protect me. And the boss renders that executive officer above the law and immune from the president, from the legal process. This case, Mustafa itself, demonstrates that the president is not above the law. How can the president's minister be above the law? Because it was the president's appointment of Patterson that the CCJ overturned. It is the president's appointment. The president's decision to appoint Patterson was quashed, was declared unconstitutional, was set aside. If the president is not above the law, how can the president render one of his minions above the law? Logically, it doesn't make sense. It cannot make sense. And that is where the legal argument will fall. In this very case, Mustafa case, one of Basil Williams' arguments from the High Court all the way to the CCJ was that the president's decision is immune from judicial scrutiny, that the judiciary cannot question the president, that the president's decision to appoint Mr. Justice Patterson is immune from judicial review. That was one of his arguments. It was rejected out of hand in the judgment. And in the judgment here, there's a whole part of it that deals with, under the caption, preliminary something. Preliminary objections. It's at page 13 of the judgment. Because that was Mr. Basil Williams' argument. The Attorney General, let me read it. Before addressing these substantive issues, there were certain preliminary objections to Mustafa's claim. The Attorney General submitted that the court lacked jurisdiction in the matter and also that Mustafa had no proper standing to initiate the proceedings. The Attorney General contended that the appointment of the Elections Commission chairman was not justiciable as it was excluded from Article 163, which reserves to the High Court exclusive jurisdiction. All set of stupidness. In other words, that the president's power was not reviewable. That was one of his submissions. And it was rejected in every court, from top to bottom. So I go back again to ask rhetorically, if the president's decision is reviewable by the courts, if the president is subject to the court, how can Jordan not be subject to the judicial process? How can Jordan, don't you think that the president could have stopped halfway the Mustafa matter? Why the president didn't intervene and stop Mustafa matter halfway from it going to the CCJ after he won at the Court of Appeal? Why couldn't do that? The way that he intervened and stopped Jordan matter from going ahead. Because he has no such power. He has no such power. I take my time and I explain these things to you because these are not things that these are things that you can't see when they happen in a state. You can't see it. You don't see it. And you can't place a value to it because it has no monetary value. But but these issues are much more important than dollar value items. This here deals with freedom. It deals with democracy. It deals with constitutionality. It deals with the rule of law. When certain people becomes above the law, then they become so powerful that they can do anything to the ordinary man. And that is what this government is demonstrating. That you know what? Their ministers can do anything. And when a citizen goes to the court for redress, because you can't, what will you do? Employ violence against the minister? You can't declare war against the minister. You can't assault the minister. Because then we'll move into anarchy. So what you are required to do in a civilized system, governed by the rule of law, governed by constitutional governance, is that you are required to go to the court and say, Judge, this is what this minister has done to me. And now when you go there, you are met with the president now. When the judge says, yes, the minister is wrong, the minister must correct his actions. When the judge says that, the president steps in and protects the minister and says, the judge can't do you nothing. Well, that is anarchy. That's a breakdown of society. That's a breakdown of the rule of law. That is a breakdown of constitutional governance. When that happens, none of us are safe in Guyana anymore, or in any society where that happens, because once rule of law recedes, then authoritarianism arises. And when authoritarian arises, it is followed by brute force. It is followed by brutality and violence. And that is what this government, that is the descent that this government is now catapulting into. That is the descent. I have written dozens of articles highlighting it. And now we are seeing that this government is descending to a different level of descent. They are now prepared to disrespect the judiciary, render the judiciary a toothless poodle against executive lawlessness. The PPP government would never, ever think of doing something like this. Never. And if ever this was ever done, Ramjatan and Nagamutu and Harmon and all of them would be on the tallest building in this country, condemning it. And we have to stand with the judiciary. And the judiciary is the last bulwark of our liberty. The judiciary is the last institution there to stand to protect our freedom and our property and our rights. And now the judiciary is under attack by the executive. That is what is happening here. The executive has declared war against the judiciary, and it's not the first time. Recall the Attorney General accosting a judge, Justice Holder, in open court, accosting the judge, disrespecting the judge, telling the judge he can say what he wants at any point in time, and no one can do him anything. The President said to the Chief Justice, you are entitled to your own opinion. The CCJ has ruled and said that you can't put these people you can't accord priority in the categories in Article 161.3, and the President is sending his delegates to us to say we must give priority to judicial people. Now the President is prepared to jump into the middle of a judicial action and render the judiciary impotent. That is an attack on the rule of law and an attack on the independence of the judiciary. And we have to stand up and stand in solidarity with the judiciary. I will be writing about this issue and I will be articulating it much more. These are only my preliminary thoughts. My instinctive sentiments are being expressed here. I hardly thought about it. But as I'm thinking aloud, as I'm speaking aloud, the principles are becoming clearer to me. The violations are becoming more flagrant. And I will be writing more about it as we go along. Time, as usual, is speeding away with me, speeding away from me, and the phones, of course, are going non-stop. Let me invite you to participate now. Caller, you're in the air.
Good night, Anil.
Good night.
Hello.
Yes, I'm hearing you. Hello?
Hello, good night.
Yes, I'm hearing you.
Own entire situation concerning the decom chairman or whatever. Granger want to rig the election.
Yes, go ahead.
I say he wants it, he wants.
That caller was not clear. Could you, when you call, make sure you speak directly into the speaker of the phone. Caller on the air.
Yes, Mr.
Mr. Nandlall.
Yes, sir.
I hear you, and everything what you say was true. The two parties will win come president for the country right now, APNU and AFC. They burn the book, the contribution book, when they come president for Guyana. Now Guyana know the truth.
Thank you, caller. Where you calling me from?
I'm calling from Rosal.
Okay, thank you.
And Ferry Bridge, it have a big hole there too. And the bridge is falling apart.
Okay, the Borbis Bridge.
Yes, and Ferry Bridge.
Yes.
Over in Amsterdam. It has a big hole there, and nobody is looking after it. I don't know if the mayor don't even go over there. Amsterdam mayor takes that bridge to go and see some people. So I don't know. The bridge is falling apart.
All right, caller. Thank you.
You're welcome.
That caller is complaining about the Borbis Bridge. Caller, you're on the air. Caller, you're on the air. We seem to have lost that caller. Please, when you get through on the phone, be prepared to make your contribution promptly.
Good night.
Good night, sir.
Good night.
Good night.
Okay. Now,
Caller, you're on the air. I don't know if I'm getting some technical difficulty, but I am unable to take some of these calls. Caller, you're on the air.
Lost that caller.
hello.
Please, when you...
Hi, Mr. Nandlall.
Yes,
Please,
Mr. Nandlall.
I am hearing you.
All right. I'm wondering, so far, according to the Constitution and the no confidence vote, this president is illegal. This president is illegal. What happened?
Well, we know that the president and the government. All right, thank you very much, caller. The Constitution says that the president and his cabinet must resign. The Chief Justice ruled that. But they are refusing to resign. They are refusing to resign. Hopefully, Friday coming, when the CCJ delivers its consequential orders, we will hear that the CCJ will pronounce that the president and his government and the cabinet must resign and elections must be held within 3 months. Caller, you're on the air.
Hello, good night, Mr. Nandlall.
Good night, sir.
Sir, I would like to tell you, as far as I'm concerned, the president, hello?
I am hearing you.
Yeah, the president is in a caretaker mode, and he is not in a position to exonerate Mr. Jordan. So I find that very,
Yes.
very, how do you explain that?
Yes, thank you. Now, that is a different dimension that I did not address. I am proceeding on the assumption that this is a normal president. And I am saying that in a normal situation where the president powers are all intact, he cannot do what he has done. He cannot do what he has done. The matter is compounded by the fact that this president is heading a caretaker government, as Justice Witt pointed out at the last hearing, and that the president's and the government's powers are limited to preparing the country for elections and maintaining basic functions of a society. So I agree with you that the president has no power in this context. And I'm saying, I'm going beyond that. And I'm saying in ordinary circumstances, had this been a president with all his powers intact, he still could not have done what he did. Caller, you're on the air.
Good night, Daniel.
Good night.
The whole situation, what I'm seeing is whole where the GCOM chairman is a Grindel want to rig election. And there is no way out that we is trying to do good thing in past. Now,
Granger has learned to read lectures under the Bonham administration. Bonham and Granger were very good acolytes.
Now, you are not telling the country anything new. All right?
Yes.
What you are expressing there are matters of public knowledge. Persons hold those views widely in society. All right? The important thing is that since we recognize that, what are we prepared to do to prevent it from happening? And that is where all of you must have a position. Are you going to be sitting ducks and allow what you claim is the clear picture? Are you going to allow that clear picture to paint itself? Or are you going to do something decisive about it? And that's the question. Caller, you're on the air. Caller, you're on the air.
Hi, good night, Anil.
Good night.
Now, from what I'm hearing here, what the president has just done, when you provide services for the government, they don't have to pay you. You're not. If you provide services to for the government, and they don't have to pay you now,
No, who is saying that?
because if they don't pay you, you can't take them to court.
Oh, yeah, well, yes, from that perspective. Yes, because if they don't pay you and you do anything about it in the court system, the president comes out and protects the minister.
Well, then we're to a full-blown dictatorship.
Well, that's the point I am making. And that's why I'm saying, without even doing the research, the legal research in the matter, what has been done there can never be right.
Could never be right.
Can never be right.
These things
On,
are
on, on, on,
crazy.
on commonsensical principles, upon basic understanding of how a civilized society works. What has been done there has to be objectionable, has to be wrong.
Thank you, sir. Good night.
Thank you. That caller made a very, very important point in his contribution. Caller, you're on the air.
Hey, I know Chris Ramsey, I'm calling from New York. Listen, I'm disgusted about this surrounding Diana. I am totally fed up. I don't know what to say. My blood pressure keeps going up. However, I'm urging you to keep the fight up, and you know, I'll be fighting over here in Europe with most of my buddies too. I don't want to go on too long, but I'm really fed up. I'm absolutely fed up.
Thank you. Thank you very much. You are in New York, far away. You are not an active participant, and you are thousands of miles away, and you are fed up. You could imagine those who are here and are actually participating in the ongoing process, how we are feeling and what we are going through. Caller, you're on the air. Hello? We missed that caller. The phone lines are going crazy this afternoon. Caller, you're on the air. Hello? I don't know. I'll have to call in a technician because I'm losing a lot of calls tonight, and the phone is ringing non-stop. The number, of course, is on the screen. I'm trying to allow it to ring a couple times before I actually take the call.
Hi, good night, sir. How are you?
I'm fine, thank you.
Okay, my question is, Friday the consequential orders will be held from the CCJ.
Will be handed down by the CCJ.
By,
Yes.
by the CCJ, yes. If the president disobeys those orders, what happens next? Thank you.
Thank you. Well, every court has a power to enforce its own orders. Every court has that power. I see the president has rendered the High Court's ability to do so otiose and impotent. That's what he did in relation to Jordan. But the court has methodologies and processes to enforce its orders. Now, however, you're dealing with a government. So a court will not want to go the extreme of issuing coercive orders. And the other thing is that when the government begins to disobey the highest court in the land, well, then there's a clear signal that the government is now acting outside the realm of the law. And international sanctions and the international community will have to now come in to deal with Guyana, because we have gone outside of the rule of law. We would have what is called tyrannical rule, not constitutional governance, but government by tyranny, because the government is no longer respecting the rule of law. The government will start to do whatever it wants, seize people's private property, take away people's freedom, etc., because it has declared that it will not obey the laws of the land and it will not be bound by the Constitution. It means that the state will fall apart. The state will fall apart because the compact, the agreement between the citizenry and the state is not prepared to carry out its side of the bargain. Therefore, the whole society breaks up. It's like as if the Supreme Court rules and President Trump refuses to obey the order of the Supreme Court. What will the Supreme Court do? Jail President Trump? So that's the dilemma that you are in here. We will take 2 more calls. Caller, you're on the air.
Hello?
Yes?
Mr. Nandlall, this is Canada calling. Shiv from Canada.
Hi, how are you?
Good. So I want to make my contribution here.
Yes.
Am I on the air?
Yes, you're on the air. You're on the air.
Okay, good. So people in Canada, I'm a businessman here, and people in Canada is really concerned about Guyana's situation. People are extremely frustrated. People in Canada is prefer to go around the world and are not going to Guyana because of about the constitution crisis. And every single body that comes to my business place are telling me that they are frustrated and they are very embarrassed. Even the kids, the Guyanese family that have kids, it's so embarrassing. Even friends from Caribbean country is laughing on us, Nandlall. I'm a member of the ACG, and it's really hurtful to see that simple thing like this, the government cannot understand and work it out so the people can be happy. It's a shame.
Thank you very much, caller, and please say hello to all the members of the ACG, and of course, hello to the Canadian Guyanese community. It's a pleasure for you to have joined, and I want to encourage more Canadians who are looking at the program to call in and let us have this discourse. Thank you very much.
Let me tell you something. Okay, sorry, one thing. Let me tell you something, Anil. You are not the amount of love and respect that you have in the rum shops in Canada, in the funeral homes in Canada, in the restaurant in Canada, in the party in Canada, people respect you. You are really fighting for us.
Thank you very much, caller. Thank you.
No people in Guyana is fighting for us because you're making our face bright by representing us. You're a great man. I'm telling you this.
All right, caller. Thank you.
Okay.
Thank you. So the sentiments the frustration that that caller refers to is widespread in Guyana, in North America. You don't have an idea how many people call me, message me on WhatsApp, message me on Facebook, text message. Everybody wants to talk about this. Everybody has a view. But it is indeed something that is really, really eating away at people and really have people upset right across the diaspora and, of course, right here in the Republic of Guyana. Unfortunately, my operator is signaling to me that we have come to program time, and once again I want to thank each and every one of you for being for participating and for viewing this program and spending the last 55 minutes or so with me. It has been a pleasure, and of course we will meet again next Tuesday when we continue this important discourse. So good evening and take care until we meet again. Thank you very much.